actually, we are at 12:31, and I am going to commence. Okay, for those of you who are on, greetings. Good afternoon. Welcome to Virtual Labor and Employment Arbitration, the Good, the Bad, and the Ugly. I am Mark Gaston Pierce, and I have just been advised by my colleagues that I'm representing the ugly. I am former chairman of the National Labor Relations Board, somebody laugh, now serving as faculty and executive director at Georgetown's Workers' Rights Institute. I'm also a proud fellow of the College of Labor and Employment Lawyers. I'm also an arbitrator, and this week I conducted my first virtual arbitration, and it went pretty well. My co-moderator is a good friend and also a fellow of the college, Homer C. LaRue, who is a professor at Howard Law School and member of the National Academy of Arbitrators, where he serves as vice president. He also serves as the vice chair of the Academy's video conference task force, recently formed to educate and train arbitrators and advocates in the use of video conferencing for arbitrations. Professor LaRue is the 2020 recipient of the Bertie Raven Award, given annually by the American Bar Association Dispute Resolution Section to an individual for long and outstanding service in ADR community. Now, I'm really happy to have Homer on board with me. I will be introducing our other panelists shortly, but I want to give you a little bit of perspective. Prompted by COV concerns that are immeasurably changing the way business is done, law is practiced, and issues are resolved, the College of Labor and Employment Lawyers, through the efforts of the COVID-19 task force, presents this webinar today. It's a discussion on the benefits and challenges of virtual labor and employment arbitration. Homer?
Thank you, Mark, and it's a pleasure to be with you and the other panelists this afternoon. One of the things in putting this webinar together that we all agreed upon is that the purpose of this webinar is not to give technical instructions on the various platforms that are available. Many of us use Zoom, others use other platforms. Notwithstanding that, there is material available for those of you who want to familiarize yourself with the technical aspects of the various platforms. Among the handouts is one that was prepared by the National Academy of Arbitrators in conjunction with the Federal Mediation and Conciliation Service, and it was delivered on April 2nd, 2020, entitled Video Conferencing for Arbitrators. I recommend that to you as a starter if you need information on the technical aspects. The objective of today's webinar is to familiarize the parties and the practitioners, and probably many of the arbitrators as well, to the virtual arbitration forum. And we're going to do that through practical experiences that will be related by arbitrators, labor management advocates, employment and labor management advocates. Mark?
Okay. Each of our distinguished panelists is a fellow of the College of Labor and Employment Lawyers. Alfred Fallu is a member of the American Arbitration Association's Complex Commercial Case, Class Action, and Employment Disputes panels, and CPR's Arbitration and Mediation panels. He is a past chair of the New York State Bar Association's Labor and Employment Law section, and in addition, a fellow of the College of Commercial Arbitrators. Mr. Fallu has conducted a number of virtual arbitrations and mediations in recent months. Robert Paul of the law offices of Robert E. Paul in Washington, D.C. has practiced union-side labor law for 40 years. Formerly with the NLRB, Mr. Paul served in the General Counsel's Office of Appeals and as an attorney advisor to several board members. He is a regular contributing editor to the Developing Labor Law, has authored several other publications regarding labor law, and has addressed various bar associations on labor law issues. Mr. Paul has extensive experience in arbitration proceedings, and since the pandemic has represented unions in numerous virtual arbitrations. Also, not seen, but guaranteed to be with us, is Amy Moore Gaylord, a partner at the Chicago office of Ackerman LLP, where she represents management and is a member of the Labor and Employment Law Practice Group and co-chair of the firm's traditional labor law team. Previously an attorney with the NLRB's resident office at Peoria, Illinois, Ms. Gaylord's practice is focused on traditional labor matters and employment litigation for both public and private sector employers. She currently serves as management editor of the ABA's Labor and Employment Law newsletter, associate and chapter editor of the Developing Labor Law, and sits on the board of directors for the Chicago chapter of LIRA. Since the pandemic, Ms. Gaylord has participated in several virtual arbitrations and one social distance arbitration. She lives in Chicago with her husband, her son, her chihuahua, and her hedgehog. Thank you, panel, and I'm glad to see you all. We all have agreed to use our first names in what we hope to be an informal, casual conversation about this very timely topic. Viewers, feel free to send questions during the talk, and the panel will endeavor to address the questions in real time. Amy, as I said, will be joining us as soon as we get through our little bit of technical difficulties. The first thing that I want to talk about is the platform that oh, there she is. How are you, Amy? We already gave your intros, your bio, and the audience was about to revolt until you showed up, and now we're okay. So I'm starting out with the technical platforms. While we don't endorse any of them, there are many to consider. Among them are Zoom, WebEx, Microsoft Teams, and other platforms that I'm not yet familiar with. In deciding on the platforms, what considerations have come into play and what kind of dynamics are involved? First of all, let me start with the practitioners. Is there anything that goes into considering what platform to use for a virtual arbitration? Amy?
Well, thanks, Mark. And again, I apologize to all of our listeners and watchers for having some technical difficulties. I really wanted to demonstrate to everybody some of the problems that you can have when you're doing a virtual arbitration or mediation. I just wanted to be an example. But seriously, again, not to promote any particular platform. I find some platforms are more user-friendly or easier to use. My firm, and I know a lot of firms do this too, is that they do require you, if you were setting up the arbitration yourself, to use the platform that's their particular preferred platform. So my firm has a particular platform that they require us to use if we set it up. Obviously, if somebody else sets it up, we'll use whatever platform they prefer. And quite frankly, a lot of times for me, it boils down to what does the arbitrator want to use. I'm always happy to use whatever the arbitrator prefers to use, particularly what they're comfortable with, because they will tend to do a lot of the moving people around in chat rooms and things. So I want to make sure that the arbitrator knows how to use a platform, that they're comfortable with it. And then sometimes, I know we're going to talk about this a little bit, you might do it through a court reporting service. And so whatever platform they're using, they might have their own, or they might use a particular platform. And so that might play into this decision as well. So that's my thoughts.
What about you, Bob?
So my experience has been with Zoom, partially because my opponents and the arbitrators I've dealt with have had some familiarity with Zoom, and the court reporting services, when I've inquired about what platform they use, it's been Zoom. So I don't have any experience with any other platform with which to compare it. Everyone seems to be familiar, somewhat familiar with Zoom. And I think people are becoming increasingly familiar with Zoom and how it operates. And in my experience, it's worked fine.
Okay, well, I know that AAA and FMCS has given instructions in Zoom, and my first exposure has been the Zoom platform as well, but I know that other platforms are out there. Arbitrators, how do you assess what platform is going to be used when making your decision? Al?
Well, I mean, it's a collaborative effort if possible, right? Certain services like the AAA prefers Zoom, but doesn't require it. I think Amy's points are exactly right, to sort of keep it simple, the ease, the user-friendly nature of the particular technology and platform. I do think folks are more comfortable with Zoom than the others, but doesn't preclude use of the others. I think the considerations beyond that would be the ability to share documents, which I think is important, certainly, and I know is important. The breakout rooms, I think, are also quite useful. And so I'm very comfortable now with Zoom and the breakout room function in Zoom. I'm not with the others. So that's another consideration. But the thing, in terms of keeping it simple, it's not just the comfort of the arbitrator. So yes, as arbitrator, I'm the host most often, and therefore my comfort with that in that capacity is important. But you also have to remember, it's not even the counsel, it's the witnesses, right? There's beyond our little circle, there's going to be a whole slew of witnesses whose capabilities and technological or otherwise are going to be quite varied. So it just makes it that much more important that whatever service you use, it's simple and easily transferable to folks who are not comfortable or used to using it.
You have anything to add, Homer?
Just a couple of points. I'm going to start with Amy's final point, and that had to do with the use of court reporting service. One of the things I think that's important for the neutral is to insist that if the court reporting service is used, they often provide a technical assistant. And I want to get the agreement of the parties that I am the host of the platform, and that any instructions that they wish to give to the technical assistant who will be pushing the buttons must go through me. So that what we're attempting to do is to create the platform to look and feel as much like the in-person hearing as possible. Similarly, if there's a court reporter, the role shouldn't change. The other point I would make follows up on what Al said about the witnesses and clients of the attorneys. One of the things I think, one of the important roles that the arbitrator plays is helping the parties to become familiar and comfortable with the platform. And so the use of a pre-conference run-through is often very useful to bringing a degree of comfort, well, if not comfort, at least a level of less anxiety to both the witnesses and the parties.
Okay.
Mark, can I add that there's a difference, but it's related, the host function versus sort of the administrative technological functions. I've had, one where I was everything and I wasn't comfortable doing that. I'm not that technologically proficient. I had one with the AAA having what they call their champions who were assisting. And then I had one with a court reporter. While I may not want to give up the host responsibility, as Homer said, I am thrilled and delighted to give up the technological responsibilities So for example, on the one where I was doing everything, I had to press, this is how technologically proficient I am, I had to press the record button when we went back on the record, and periodically needed to be reminded to do that because that was such a burden on me. But there's a difference between the technological issues and the hosting issues.
Mm-hmm. Okay. Well, it seems that arbitrators certainly have to get fairly proficient in utilizing the various platforms. Of course, there are some more common than others, but I think that probably is a factor as well. Homer, can you discuss with our panel some of the stories from the trenches, particularly with respect to what kind of experiences and the general distinctions that might be experienced in a labor arbitration versus an employment arbitration?
Certainly. Now, I have had experience both primarily with labor and traditional labor management arbitration, but I also have done and continue to do employment arbitrations. So I can speak a little bit about both. I haven't had any employment arbitrations post-pandemic, but pre-pandemic I did. And I think the distinction is probably overdrawn, that the use of video conferencing for labor management arbitration is not that different from video conference arbitrations in employment, with one caveat. And I think this is what I would like to ask Al about his opinion as well. And that is that in the labor management context, although this is becoming less true, there is less emphasis on pre-arbitration matters than in the employment. Employment tends to be very document heavy, and therefore the pre-hearing material, the pre-hearing document handling is very, very important. But as I say, post-pandemic, my experience is that that distinction is becoming less important because the need for pre-hearing exchange of documents in a labor management is becoming as acute as it is employment. Al, what's your experience from the employment perspective?
Well, by its very nature, employment, the discovery is much more substantial. That's just the template. It's much more litigation, mirroring litigation than traditional labor. So, I mean, that's a truth. The question is, what does the virtual nature of discovery and/or hearing? Frankly, my experience has been, come March, the cases that I'm referring to that went to hearing were ready for hearing. So the pre-hearing had principally occurred. So the need for virtual, whether it's depositions or whatever the issue might be, was lessened. I think going forward now, while we're still in this pandemic, the whole deposition, I think now people have transitioned into clearly and assuming that everything's going to be virtual in terms of pre-hearing. When you get to the hearing, what happened pre-hearing is interesting, but secondary. There may be things you can do pre-hearing that will facilitate the hearing. Obviously, stipulations. I mean, there are things you can do that will make the virtual hearing proceed, hopefully, more comfortably. But beyond that, I'm not sure how much pre-hearing can impact what's actually going to happen at the hearing, whether it's labor or employment. I think we end up in the same place. I think once at the hearing, and you tell me if it's not a truth, but for me, it's the assumption is that there's going to be far more use of documents and maybe deposition transcripts and things like that in an employment case. So there are those issues, those complications of how do you use exhibits, which I hopefully will get to later in the context of a hearing, of a virtual hearing.
Yeah, we will move to that. Thanks, Al. We will move to documents. But before we do that, I'd like to ask Bob first and then Amy to talk about to what extent do you think it's important that the case is either a discharge case or is a contract interpretation case in terms of deciding about the viability of a video conference. Bob?
Well, from my standpoint, as representing unions and trying to move a grievance typically filed by an employee or the union against management and moving that to get a decision, it doesn't matter a whole lot. My goal is, on behalf of my client, is to try to get the case heard and get it decided. Clearly, there are circumstances, particularly with a discharge case, where you've got a back pay liability running again for the employer potentially, that maybe both parties are interested in having a hearing more quickly than in a contract interpretation case. And I've had those discussions with counsel and with arbitrators more early on in the pandemic. I think now, given that we are almost into August and the pandemic's here, at least for, unfortunately, some time to come, I think those distinctions might be lessened, since if we wait until the pandemic is over, we might not know when the hearing will take place.
Amy, what about from the management perspective?
Well, I kind of think Bob hit the nail on the head. You know, oftentimes, from my perspective, if I have a discharge case, I do want to move the case along, because every day that the case isn't heard is another day of potential liability, right? But same goes somewhat with a contract interpretation case as well. If it's a isolated violation versus something that's going to keep happening over and over again, and you know, we want to put an end to it if in fact it is a violation, or know that we're able to continue to do it. So there is some of that in considering a discharge versus a contract interpretation. I also, you know, going to witness credibility, which I know we'll talk about, some of it will depend on my witnesses and how they come off in a virtual hearing. How do they come off on camera? Are they better in person? So there's some of that analysis, I think, that goes into it as well. I know some people who come off very credibly in video conference, on the telephone, but there are some people that just aren't comfortable, and that lack of comfort can come through when a witness is testifying. I've seen it happen, you know, and just that lack of familiarity and comfort can make it seem as though perhaps a witness is being less than truthful. But, you know, that goes, I think, you know, and Bob, I'm sure will agree, to the practitioner's responsibilities in preparing their witnesses, making sure they're ready. So there are some considerations, but I think, you know, there's the same considerations regardless of whether it's a virtual or in person.
Okay, we will move back to the question of credibility as a distinct issue, because it certainly arises quite a bit. Let me return to something that Al mentioned in his statement with regard to the pre-hearing preparation. And then, Al, look at, I guess what I'd like for you and I to do at this point is to kind of counterpoint employment labor management.
Sure.
So as we talk about, for example, witnesses and stipulations, what jumps out at you in the employment situation with regard to stipulations?
Well, I mean, the distinguished the affidavit, the direct testimony by affidavit versus stipulations. You know, stipulations could be anything, facts, stipulations, legal, you know, agreeing to certain New York law is going to govern, you know, whatever the particulars are. I'm generally not a fan of direct exam by affidavit, but, you know, these hearings, Zoom or otherwise, are pretty exhausting, and no one wants to sit in front of a screen for, you know, 2, 3, 5 days. So I did have one case recently where the agreement was that all direct testimony for every witness would be by affidavit. Again, I never say no. If the parties want it that way, that's fine. Generally, they don't, frankly, and I certainly don't mandate. So that was an example of addressing the concern that this was going to go on too long, that there might be technological issues. Let's find ways to expedite. And that was the parties' willingness. I think there was a panel of 3. I think we raised it, and the parties accepted and agreed. So there were those issues. I think it's just this, you can't force parties to stipulate to facts or to the law. So you encourage them, you try to reason with them. If anything, I use sort of my mediation skills rather than dictating to the parties what they need to do. Counsel, is there anything else we can do to facilitate the the sort of typical exhibits are going to be challenging, and the handling of exhibits. What can we do to expedite that? Can we agree, for example, that all exhibits are authentic and admissible in the absence of an objection? That's a typical one I would normally do, but I would especially want to do in a virtual hearing. So again, I think the handling of exhibits and just the management of the hearing, whatever you can do pre-hearing would be advisable.
Can I jump back a second? Because
Sure.
I think there was with respect to the pre-hearing conference, there was a question that just came in. Do witnesses have to participate in this pre-conference call? And if so, would subpoenas be necessary to get the witnesses to participate?
Homer, why don't you go first?
Okay, my practice is to alert counsel that their witnesses are certainly invited to participate. Obviously, my subpoena power only permits me to compel the witness to show up on the hearing date. So if the witness who has been subpoenaed isn't going to do it at the behest of the other party, then I have no power to compel that. What I do say to the advocates is that if you do have witnesses who are uncomfortable, as Amy was describing earlier, I encourage you to have them at this pre-hearing so they can see what this platform is about, become more comfortable with it, and ask whatever questions they may have. And thus far, I haven't had a problem with that.
Yeah, I have my experiences to try to have witnesses come to these hearings, but people are just generally using Zoom in social conversations with other friends, with members of the family. So people are becoming more familiar with it. But I think it's critical for counsel to have an individualized conversation with each of their witnesses to make sure they understand the platform and how it will work, and answer any questions, and hopefully do a rehearsal via Zoom if that's going to be the platform, so that there aren't any hiccups when people sit down for the hearing.
Yeah, just go ahead, Amy.
I agree with Bob. And one thing, just to differentiate, a lot of people are, using more Zoom. I have Zoom, happy hours with my friends and my family and things like that. But they might not be familiar with all the functions of Zoom. They might not have used the whiteboard or sharing documents or anything like that. So I definitely encourage, number one, to have my own conversation with each of my witnesses and my parties, but for them to come to the pre-hearing as well, to see how it works, to see the arbitrator, see how things are going to operate. I think it just, again, goes to our role as practitioners to make sure that our witnesses are comfortable with everything that's going on. And that would be regardless of whether it's virtual or in person.
Yeah, let me be clear. When I mentioned pre-hearing, I was envisioning the management conferences with counsel, which before even Zoom issues were always telephonic 99.9% of the time. So occasionally now they may be virtual. I've never had a witness on one of those calls. Those are really pre-hearing or discovery related management conferences. So there's not even a thought of a witness being there. What I do, and we'll make reference throughout this webinar to orders that Homer and I typically impose or sign as part of the pre-hearing. And in that order, I direct, encourage, beg counsel to work directly with their witnesses to do the run-throughs. Now, some have gone the next step and said, we'll have a run through, not through the testimony, but just on the technology with witnesses. I have not done that. I'm not comfortable doing that, imposing on people in that manner. I'm expecting the counsel will be responsible enough to do that. I have to say the report card is pretty poor. Counsel has not done as good a job as I would hope, and we do the fumbling around, not to mention any names, but trying to get people on, or there's the technical issues, or so I just, maybe I'll get more aggressive with age, but as of now, I'm still relying on counsel. I might get more forceful in my direction, but But I rely on counsel to take care of those pre-hearing issues or the technological issues.
Al, wonder if you would say a few words about something you mentioned, and that's your pre-hearing order. Both you and I have provided for the participants two case, well, I call it a case management order. Describe a little bit about what you have in yours in an employment, and I will describe a little bit about what I have for labor management. But remind the participants that both are available as handouts as part of the webinar.
Yeah, if you look in your little box there, you can pull it up. And before I get sued, this is the triple. I took the AAA's very, very fine template, I have to say, and modified it to suit my needs and to particularize it to different cases. So what I provided to the attendees was a variation on the theme, you know, of some my modification of what is otherwise on the AAA website for their Zoom related hearings. And what it does, I mean, again, you can look at it yourself. It addresses if there's an issue about whether, if there's a dispute about whether it should be virtual or not, I would put in the first paragraph there. I unfortunately, the template I gave you did not have that paragraph, but where I'm required to order over the objection of a party, I would put it in there. We go through the recording, you know, whether or not it's going to be recorded. Is there going to be a court reporter? Is the court reporting service going to record it? You know, is it going to be a Zoom record? You press a button and you Zoom, you know, you record it through Zoom. Some of the technological aspects, you know, the testing of the system, directing the parties, the counsel to work with their parties and witnesses to have a backup. You know, sometimes we get so, we rely on technology too much and we get too creative. The backup that we use, certainly in at least one, maybe two of the three that I'm referencing, was a conference call, an email. You know, counsel, if we get disconnected, you know, let's make sure we're all connected via email and we can communicate that way. Or if there's a break, if there's a lunch break, all right, if 10 minutes over, you know, let's get back into the hearing, whatever, or a cell phone if necessary. So backups if things go, you know, if things go wrong. So it just goes through a series of recitals, some very useful, some somewhat mundane, but I've made it now standard. I vary the template depending on the case. But, you know, address some of the witness issues. Again, you could see them yourselves and we can particularize it, but that's what I'm referencing when I reference the virtual hearing order.
And mine is not unlike that of Al's. The only thing I would say is that I call mine, this first order is a sample case scheduling order because I send it out at the same time that I offer dates to the parties for the video conference. So obviously the assumption is that the parties have agreed to a video conference. What they haven't yet agreed to is whether I will be hosting the platform or they have some other. And so I will give two options and ask them to select which option they want to use. After that, I pretty much do what Al says as well. I describe the virtual hearing space. I'm afraid this all of the pages of this order didn't get printed. I hope that it did in the handout, but what I have doesn't. At any rate, if there are discrepancies, we can certainly take care of that after the program.
They're all there, Homer.
They're all there. Okay, it was just my printer then. Okay, thank you.
Someone had a question, and that is, at least some of these platforms include, including Zoom, permit recording. Are the arbitrators comfortable with using the recording device rather than a stenographer?
I don't think that's the only question. I think the question is, are we comfortable with using the recording device? Are we comfortable with using the recording versus stenographer? Are we comfortable using some sort of recording? My personal preference is that I don't use the recording device on Zoom. I will use a court reporter, and otherwise I take notes the old-fashioned way on my computer. I found that the recording on Zoom and others disagree. I find it too difficult to go back and use it in an efficient way, that my notes are a better recording. Al, you have a different?
Yeah, mine's answer is a little more nuanced. I think I don't require, maybe with one exception somewhere in 25 years, to have parties have a court reporter if they choose not to. It's an expensive endeavor. And so if the parties come to me and say, we're not willing to have a court reporter, you know, in the old days and still today, if there's no court reporter, my notes are the official record. So that's one scenario. In one of the cases, the parties did not want to pay, and they agreed to do the Zoom recording. That's what I was referencing before, where I had to press a button. So the way we did that, we agreed it wasn't an official record like a transcript, in the sense of people, you know, would cite it with great authority, but they could reference it. They could go back and review it for their own recollection purposes. Because as was suggested, if there's breaks, you're not going to want it to record all the way through the break. So after every, you know, we would take a break, I would stop the recording, and we'd come back and I would start it again. So to make some rational use of it, I think, Homer, you're alluding to it, you know, it would be segment 1, segment 2, segment 3, because the cross-examination of Smith was in segment 4. And at least if someone wanted to go back and review it, they had that. But that's pretty rudimentary, right? That's not terribly professional. I certainly had a court reporter service and a court reporter, which is of course heaven for an arbitrator. And I'm thrilled. There was no, in that case, for reasons not worth everyone's time, one of the parties wanted to record it, the other one didn't. So we allowed them the court reporting service to record it, but made it crystal clear it was bound by the confidentiality order that had been entered, that it was not any sort of official part of it. It wasn't going to be submitted to me in post-hearing memos. It was for whatever purpose that particular party felt would assist them. So in terms of this whole recording issue is a really important one, and one that the parties and the arbitrator need to work through, certainly before the hearing.
And one of the details that they need to work through is, remember, when you transcribe that recording, do you want the chats, because the chats will come with it, and so you want to be, the parties and the arbitrators need to be very aware of that and make their decision with that knowledge. Bob, you wanted to get in here.
Yeah, I was just going to mention that point that you made, which I think is very important for practitioners to understand. And in my experience, the court reporting services use the recording function as their own backup. So while the court reporters at the hearing, the audio recording or video recording of the Zoom is available to them if there's a question about what someone said, but it's not otherwise used.
Amy, did you have a different perspective or another one that you would want to bring out here?
No, I was just going to echo that. And I think we mentioned this before, that, you know, there's these chat functions and platforms like Zoom and whatnot, and they allow you to chat privately. But it's my understanding then that if you have the recording, that those chats then become public, that
Right.
Anybody with that recording could see it. And I guess I would have some concerns about if I was having a chat with my client, you know, attorney-client privilege, or the arbitrator possibly being persuaded in some way by whatever the chat might be. It might be taken out of context or whatnot. So that's a concern I have in terms of recording. But I certainly would be acceptable. I think it would be acceptable to have the court reporting service use it as their backup. You know, I think that makes sense. And normally they have some type of recording anyway.
And Homer, one more point, if I may. Yeah. You know, the video, I'm not sure at the hearing it's going to make that much of a difference, because it's not at a hearing. Generally, the video of a hearing is not terribly important. The video taping of a deposition, you know, has certain uses. And because of the expense, I think many parties wouldn't videotape the deposition. But if you're taking a Zoom deposition and all you have to do is press a button, and there's no cost to doing so, I think you're going to see a lot more video depositions, which to the hearing.
And I believe the college has either run one of these webinars dealing with that issue or will be soon. Let me move on, aware of that we have limited time and we could talk about each one of these issues all afternoon. But I want to touch very briefly on exhibit marking and sharing as part of the pre-hearing preparation for the employment hearing and for the labor management hearing. And Al, I'm going to start with you to explain to our audience, how do you handle that?
Yeah, look, again, maybe it's a gross generalization, but the exhibits, tend to be more substantial in employment cases. You can have, I've had cases where you have 6, 7, 8 3-ring binders, on the floor all over the place trying to work through. Since lawyers are not terribly technologically proficient, they tend to be hard copy and not virtual, not digital. So you certainly want to work through the issues. You usually do, right? Trying to get parties to agree to the admissibility of documents, to the pre-marking, try to avoid duplication of documents. Can we have joint? But this would be normal in a normal management of the hearing, pre-hearing matters. But it becomes that much more important. For me, the concern, and I hope this doesn't make me a technophobe or an old fart, but in my experience to date, while I compliment Zoom in the sharing of documents, I do think it's relatively mindless and works relatively well. There are problems for me. We're going to talk about credibility. If I have a document covering most of the page, my access to viewing the witness is limited. I just can't tell you how many times doing the process of just trying to bring up the exhibit. All right, now we have a 50-page exhibit. Madam Witness, have you ever seen this document before? No, I need some time to look at it. Now what do we do? And if I'm the host, am I scrolling for her benefit? Or do you want me to turn to page 3 now, page 4? So there are those issues. If you have a second screen that, that might facilitate some of these concerns. So there are just some practical issues. And again, while, the lawyers and the arbitrator and parties may be proficient, the witnesses often are not. So bottom line, to the extent possible, and when it's practical, I urge the parties to do basic hard copy to the witnesses. So in my last few, what happens if they're really concerned about the witness seeing the exhibit beforehand? I think that's so often overblown, but fine, if that's your concern. Then you put it in the manila envelope. There's claimant exhibit 4. Okay, Madam Witness, please open claimant exhibit 4, and they take it out. But I do find it just works so much better. And frankly, the witnesses, depending on the sophistication, are more comfortable with a piece of paper that they can look at their leisure. And so I am tilting significantly towards hard copy whenever possible. Unfortunately, given the pandemic, it's not so possible in certain situations where folks are not in their office. They don't have the big, photocopy machines to make those copies. It's not easy to collate and do whatever one needs to do. So with some flexibility in that mind, that's the way I would prefer. But if the parties can't, or it's expensive, or they say no, then we deal with the Zoom capabilities for sharing documents or whatever the platform is.
Amy, what's your reaction to the arbitrator who asks you to deposit documents in a document sharing file such as Dropbox? Do you have any problems with that? Do you push back on that at all?
No, I'm perfectly comfortable using any Dropbox or any type of file sharing system. To Al's point, I do prefer I also enjoy having paper exhibits, having hard copies. And I do like to have my witnesses have hard copies. I have done a number of these, both virtual and in person since the pandemic started. And it really has gotten to the point where, you're really, even without any, because I only do, just to clarify, I only do labor arbitrations. I don't do employment arbitrations. And so I've gotten to the point where I'm very comfortable now sharing my, exhibits in advance. Also, I do a lot of public sector work. And so a lot of times the union is sending me FOIA requests far before the arbitration. So they've gotten all the exhibits or anything they're going to use in advance anyway. So it's very far and few between that there's some type of gotcha exhibit or something I'm going to spring on somebody at the last minute. So, I'm perfectly fine sending a hard copy to the arbitrator, to the witnesses, if that's what they prefer. But using a Dropbox or any of those other file sharing systems is also works for me as well. Or I recently just had one where I was sent a zip drive of the file of the exhibits. And I also, and I'm sure Bob can weigh in on this as well, try to agree on joint exhibits as much as possible so that we are working from one set of uniform exhibits. The last arbitration I had, I think 80% of the exhibits were joint exhibits. So that's my perspective.
Bob, from the union's perspective?
So I'm fine with using a Dropbox or a similar depository for the exhibits, but my preference, as with Amy, is to get hard copies to all the witnesses and to opposing counsel. I try to work out in advance with opposing counsel that we will exchange hard copies of the documents a day or two before the hearing, with a proviso that if during the hearing there, a gotcha document comes up, that you can then email that document to counsel, to the arbitrator, have counsel forward it to the witness, or you can do that if you have the witness's address. I really think it's important for the witnesses to have hard copies in front of them. As we've said several times so far, most of the witnesses, at least certainly on the union side, particularly if they're employees, are not going to have extensive experience with this mechanism. And trying to go through a multi-page document on screen during the middle of a hearing is not going to be comfortable for them. So I'd really prefer that hard copies be available for all the witnesses and, of course, for the arbitrator.
Okay, while there are a number of other factors that we could talk about, things like the confidentiality, I think we've touched on a little bit. One of the concerns that's raised with regard to video conferencing is issues around coaching concerns. One of the important things that we all know as fellows of the college is that what we're trying to promote is civility among all of us as we go through advocacy. And so while we can take care of some issues, there are others that are going to be left to the mores of how we act toward one another. And I think some of the coaching concerns can be overdrawn in that respect. Same thing with site visits. I think that we could talk about site visits for a long time. What most of us have found, I think, as advocates and as arbitrators, is that in the pandemic era, there are other ways of doing a site visit that don't depend on everyone being there. And usually we can find a way to work through that. There are lots of other issues, but I'm going to turn it back over to Mark, who wants to get us into some of the other things that we need to touch on before we move to questions.
Thanks so much, Homer. I just wanted to mention with respect to the last couple of subjects, with respect to, because there's been some questions about credibility concerns and so forth. Can an arbitrator really assess credibility when they're looking at somebody's Zoom testimony? Of course, from my perspective, if you have an in-person arbitration nowadays, everybody has a mask. So how credible does somebody who looks like they're going to knock off a liquor store look and when given testimony? So I just want to briefly get your take, both arbitrators, with respect to the credibility question.
How are you go first?
I'll be happy to. I think one of the, if it's not here, it's on the NAA website. I wrote a paper back in September 2019 for the National Academy of Arbitrators concerning video conference hearing, and the last part of the paper deals with credibility. I'm not one of those arbitrators who relies heavily on demeanor evidence and thinks that that's dispositive. I think that for a host of sociological and psychological reasons that have been empirically documented, that's very unreliable, even though courts still give lip service to demeanor evidence. Does that mean that I don't look at it at all? No. But is it dispositive? Probably not. What's more dispositive for me is the consistency of the witness's testimony with what seems to be not in dispute or very close to not being in dispute is a much more reliable indicator of credibility than demeanor.
Look, I mean, certainly not having done virtual hearings until the pandemic, it was a concern just out of ignorance, right? Just it's something new. It's a concern. I don't know how it's going to work out. I have zero concern now. I've heard some of my arbitrator colleagues say that in fact they think there's a better tool for assessing credibility. I'm an arm's length away from the witness. I'm looking at them the entire time. I'm not 5, 10, 15 feet away with a court reporter in between and 50 documents and a lot of noise and distraction. So I just have not found it to be an issue. I really haven't, and frankly, in ad hoc polling, have not heard that from I have heard the same from my colleagues, that it's just not a significant concern, if any concern at all.
I could just add, I've had several experiences where my opponent has resisted going to a virtual hearing because of this issue of credibility. And whether that was a tactic to delay the hearing or not, I had arbitrators in the 2 instances carefully and gently explain to both of us why credibility isn't going to be such a big issue for the reasons that Mark mentioned, that everyone's 6 feet apart, everyone's wearing masks. It's going to be hard to judge someone's credibility under those circumstances. You might be better off in a virtual hearing where the arbitrator can actually see the witness and evaluate his or her testimony.
Okay, all right. Well, I'd like to move on, and there's plenty that we left on the table, but we have to move on. What factors contribute to the decision to go viral? I know there's a lot that goes into that decision making and a lot of dynamics, but let's start at the floor. There's an authority that the arbitrator has, and can our arbitrators discuss their authority with respect to making that call, and how does that impact on the decision-making process? I'm particularly going to talk about refer you to the National Association of Arbitrators Advisory Opinion 26, and there are some rules with AAA that are relevant in that respect as well. Homer, why don't you start?
Sure. The National Academy of Arbitrators, once the pandemic broke, was faced with the question, and the question that we were faced with from many of our members is, can an arbitrator order that a matter proceed by way of a video hearing at the request of one party over the objection of the other party to the arbitration? Now, we'll be having a number of webinars, we meaning the National Academy, discussing many of the nuances in this opinion, so I'm not going to go through them in detail. The short answer to the question, however, is yes, the arbitrator can. The longer consideration that the opinion suggests is that there are a number of considerations that the arbitrator must take into account before making that decision, and that it should not be a decision that is made lightly, and it should not be made without discussions with the parties and with careful consideration of what they are raising. But at the bottom line, at the end of the day, if the arbitrator believes that he or she has taken into consideration all of these elements, then the Academy takes the position that an arbitrator may, not must, may order the hearing. So that's the short answer to the opinion 26. There are other aspects of it that we probably don't have time to get into that we could discuss as well.
Al?
Even shorter answer is yes, the arbitrator has the authority. I think, Rule 11 of the AAA rules say the arbitrators shall set the time, the date, time, and place for the hearing. I don't think there's any doubt that the arbitrator has the authority. It's the proper use and exercise of that authority, the common sense aspects of it. So is it possible there's going to be some vacature because an arbitrator irrationally imposed a virtual hearing? Sure, it's always possible, but as to whether they have the power, I don't have any doubt that they do.
Practitioners, Amy, had you ever been concerned about whether or not the arbitrator has the authority to pull that trigger, or did that impact your decision to participate at all?
No, I never doubted that the arbitrator does have the authority to order the time, place, and manner of hearing. I have very fortunately not been in this position. In the cases I've been involved in since the pandemic began, both parties have been in agreement for a variety of different reasons, whether to go virtually or to go in person. And one thing I have heard, and Bob can probably speak better to this, but some of the local unions that I run up, that I'm against often, have said that they have travel bans. They actually can't go, like if we're going to be in Indiana or Wisconsin or whatever, they're not allowed to travel. So I have had that circumstance, which obviously would drive the virtual nature of the hearing if people cannot actually travel legitimately. So I just haven't had the experience, but I don't doubt that the arbitrator has the authority to order that a virtual hearing, regardless of the opposition of the other party.
Bob?
So I agree, the arbitrator does have the authority, but I've had opponents several times, particularly during the months of April, May, and June, argue strongly that the arbitrator really doesn't have the authority, but even if the arbitrator does, shouldn't exercise the authority. And I think, when the pandemic was first upon us in March, I think we all had hearings canceled right away because no one knew how long this was going to last. And a postponement for a couple of months is sort of the ordinary course of business. But now that I've had cases where it's been postponed 3 or 4 times, because each time we approach the new date, the employer argues that they want it postponed again because they want to wait until we can have an in-person hearing. But I think as time moves along, and we're now almost into August, and we don't see a light at the end of the tunnel, I think it's going to be a harder argument to make that the arbitrator shouldn't go ahead and exercise the arbitrator's authority to order a virtual hearing. I've also had, as Amy mentioned, I've had opposing counsel say, I can't come to a hearing because my firm is banning travel. So, and all of that's a legitimate consideration for all of us. So these issues have come up.
Anecdotally, Mark, what I'm hearing from a number of arbitrators is what Robert just indicated, the can being kicked down the road a couple of times. And so now from the time that it was scheduled to go in March, it's two months, sometimes almost going into 3 months that the hearing is set. And what a number of arbitrators are now doing, as I say, this is anecdotal, is saying, all right, we've postponed this twice. Here's the 3rd hearing date. This matter is going to go forward in person if possible, but if not, it's going to go forward via video hearing.
Yeah, I had that exactly happen to me. An arbitrator issued an order to that effect.
Exactly, I had the same thing happen as well.
And that was the script of my arbitration that went this week, virtual. Of course, there was a chapter where we considered a social distance arbitration on the roof of the office building so that we'd be outside. But of course, as you know, Bob, this was DC, and that day happened to be 100 degrees. So we decided to come up with another plan. But this was, of course, after.
Smart thinking.
This was, of course, after kicking the can a couple of times and doing just as has been indicated anecdotally and Bob and Amy's recollection, a time certain date certain where the arbitrator says, well, now, if it's going to go to this, we're just going to have to do it virtually. Now, what happens, and this is to you, Al, have you experienced a situation where one party objects and the other one doesn't?
Yes, let me separate the time frames. So the March-April time frame, where whatever the objection was, the reality was going to overwhelm the objection, and we need to proceed, those kinds of arguments. But yeah, of the 3 virtual that I've had, 1, there was an objection. Yeah, how strenuous the objection was, how genuine, it's hard to gauge. Was it the client or the lawyer? My sense, with my big Italian nose, the smell was that that it was really a function of the senior lawyer's discomfort with the process. I tried to reason with him through the process and give some comfort, but the objections just weren't powerful or potent. It was just this indefinite, it's not the right way, God didn't intend it. Look at Leviticus 3:14, it's not there. So ultimately, I have to tell you that the pleasure was at the end of the hearing, kind of gently asking, how'd we do? 40-year trial lawyer, not comfortable with the process. And I think he got comfortable. Look, we're all growing. This is all brand new. I was uncomfortable equally, but we all had a job to do, and we had to get the hearing and the case in. So, but yeah, I did overrule his objection. As I said, the order that I have there, I didn't include the paragraph, but I have a paragraph. Just I'll quickly read it. I note the objection of respondent. The arbitrator finds, however, that conducting the hearing via video conference is a reasonable alternative to an in-house hearing in light of the COVID pandemic, stay-at-home orders, and travel limitations. Video conferencing technology will provide the parties a fair and reasonable opportunity to present their case and will allow the hearing to move forward on the dates previously scheduled instead of postponing the hearing to a future date. And I note that it had already been adjourned once. If some court wants to overturn me because I ordered it, that's their privilege, but I thought that was the right thing to do.
Well, that might be the answer to this question, because this question says balderdash. I have a disagreement with the panel on the arbitrator's ability to order a virtual hearing over a party's objection, at least in cases where arbitration is being conducted pursuant to a contractual arrangement between the parties that do not adopt the AAA rules. What say you that, gang?
Well, with regard to labor management, we're not necessarily only dependent upon the AAA rules. I cited the NAA's opinion 26 as the basis and the rationale for being able to order a hearing. And if you notice that the code also permits an arbitrator to, as do the AAA rules, to permit the arbitrator, although it should be rare, to hold an ex parte hearing where both parties have been given full notice of the hearing and all those other considerations have been on the table for that entire time. The arbitrator can go forward with the hearing and order that the moving party present his or her case.
The question goes forward to say, well, what if the language of the contract says hearings are to be in person, in DC, does the arbitrator have the authority to challenge the language of the collective bargaining?
My opinion is no, that we are creatures of the collective bargaining agreement. If the parties have agreed to how they're going to run their hearings and that they will be in person, and that language hasn't been interpreted, then I'm bound by it as the arbitrator, it would seem to me. But my guess is that what's going to happen is someone is going to arbitrate that issue.
Okay, all right. Well, I want to move on and get into probing a little bit more on the decision to go virtual. from the practitioner's perspective, is it ever the dynamic where the practitioners might feel, well, we're pretty agnostic about the decision, but our clients might have the problem, so we probably would rather the arbitrator make the call? Amy?
I have not had that. Like I said, in all the cases I've done, either to go virtual or to go socially distanced hearing, the parties have been in agreement. So I just haven't had that particular issue come up.
Amy, could I just jump in here and ask one question about that? How would you gauge the comfort of your clients with the video conference? This issue of disagreement put aside.
They've been fine with the video conference. And I think we were going to talk about this a little bit later on, so I don't want to jump ahead, and assuming we get to it. But where I've had resistance or wanting to have a in-person hearing is largely clients who have been essential businesses and have been operating the entire time. So folks who've been in the workplace. So when you have witnesses come in, it's not as though you're exposing them to something that they haven't been exposed to every single day that they've come to work. So I want to clarify that. I think it's a very different situation if you have, employees who are working remotely in a workplace that has been, work from home over this period of time, such as my workplace is. I'm sure most of you are as well. Then calling those witnesses into a in-person hearing, as opposed to, again, people who have been, working time and again, firefighters, police officers, folks like that. It's a very different situation.
Mm-hmm. Now, when you had that resistance that we're going to get into later, where was it coming from? Your client or the other side, or what?
Both.
Okay. And Bob, have you been in a situation like that where there was pushback from your own client about the virtual arbitration?
No, I haven't. I mean, I've had two sort of categories of cases, one where both sides agreed under the circumstances we're going to have to do a virtual hearing and there was really no issue. And a second category of cases where the union wanted to proceed virtually given the circumstances and the employer resisted for one reason or another. Not because of some, just my perception, it wasn't because of some discomfort level with the platform. It was just the idea that in-person hearings are preferable for all of us. I think we all agree with that. And they just wanted to insist that the arbitrator sit down in the same room and look at the witnesses, and evaluate their credibility.
Okay. So in the situations where the client was resistance, Al, you talked about, to some extent, you have done your best to bring the parties along with respect to the value of pursuing the virtual arbitration. But oftentimes that's a discussion between counsel, and the resistance may be coming from the client itself. Do you or Homer have any suggestions with regard to how to deal with those particular types of challenges? Why don't you start, Al?
The challenge being the client behind the scenes is unhappy, but the counsel sort of alerts me to that issue.
Yeah.
I'm not one of those who, requires the client to appear. I in that situation would likely try to team up with counsel. Well, counsel, I would be delighted to have a conference with your permission, with the clients on both sides so we can talk through the issues. So, but am I likely to order and try to berate the client, or I'm not likely to do that. Look, if the parties agree to do it virtually, we do it virtually. If they agree not to proceed until we can do it in person, I'm a creature of contract. I follow their mandate. It's only if there's a difference of opinion, but I don't usually probe behind the counsel's get behind the counsel and try to get to the party.
I would agree pretty much with what Al has said, but something that he'd said earlier that I would go back to as well. Many of us who do arbitration also have some skill and background as mediators. And I think that in the context of our managing the arbitration, we might think about those opportunities in which we might be able to facilitate these conversations. And so inviting counsel, both counsel, to have their clients in on a conference with me in which I can talk to everyone. Ostensibly, I'm talking to the clients. The lawyers already know what I'm talking about. It's just like we do in a mediation. We talk very often past the lawyers to their clients. And I think that's something that the neutral needs to keep in mind, that that should be in the arbitrator's bag of tools.
Okay. Amy, have you had to coax your client in these situations, or have they all been with full cooperation?
Yeah, again, my experience has either been they were fully on board or they were fully opposed and they wanted a in-person hearing. And it was the same on both sides. So, and you know, one thing I did want to point out, I think it's worth mentioning, is, like I said, I only do labor arbitrations. So I'm dealing with the same opposing counsel, 90%, you know, the same folks over and over again. And I'm going to be across the table at the negotiation table every 3 to 5 years with the same folks. So we have very good working relationships, even if we don't, you know, always agree, of course. We have a degree of trust and mutual respect. And I would just say that from a labor perspective, I think makes it a little bit easier as opposed to the employment perspective, where you might only see opposing counsel for that particular case, and maybe, you know, once more in your practice. And in terms of my clients, they've either, like I said, been really in favor of it and we were on the same page as the other side, or they were really opposed to it and we were again on the same page as the other side. So I wasn't really trying to convince anybody.
Mark, can I add to that? Because I think that's a crucial point.
Sure.
The gamesmanship on the employment side, the chance for gamesmanship is far in excess, I think, than in the normal, healthy collective bargaining relationship because of the ongoing nature of it. If you do something to me this time, I get a chance to do it to you next time. I don't, in the employment setting, well, occasionally it happens. For the most part, they're never going to see each other again. If not, maybe counsel might, but the parties won't. So you don't have that restraint. So the arbitrator has to be more forceful at times, just because there's the gamesmanship, right? The delay, let's just take the delay, adjourn. Well, that could just be strategic to benefit, you know, one side who's got an interest in delaying. And if the arbitrator is unwilling to put his or her foot down, then someone's going to take advantage of the process. So Amy, I can't tell you how important that point is.
Well, there's one more question in this area. What about the disparities in the availability of technology? Everybody doesn't have the same kind of equipment or internet speed. In fact, when I did my virtual arbitration this week, we had to postpone for an hour because one of the parties' internet speed was unstable and that party had to go to another location where the internet speed was more solid. I understand that these things kind of happen. What do you do in that situation? What if you have a witness that, you know, has dial-up or DSL? Bob.
Well, first of all, there needs to be some advanced planning on the part of counsel. We need to talk to our witnesses, make sure what equipment they have, what their level of sophistication is with the equipment, and do a dry run to make sure that that works. But that said, hiccups happen. I've had a case where I think the first Zoom arbitration I had, the power went out at the arbitrator's house for a while. And so suddenly there was no arbitrator. And another case, the grievant had some electrical issue, and believe it or not, at his house. And so we had to wait. But what I try to do is make sure before the hearing I have everyone's cell phone numbers, including the arbitrator, opposing counsel, of course, email addresses, and just try to stay in touch and go through these sort of road bumps, because they're going to happen from time to time, and we just have to work through them.
Okay.
Yeah,
Amy, go ahead. I'm sorry.
I was just say, I absolutely agree. I mean, even in the best of circumstances, when we're doing everything, pre-pandemic, you can have things happen, right? I was on the way to negotiations last winter and I got a flat tire. So I ended up doing the negotiations on my cell phone on FaceTime from the car dealership. We do what we have to do. So, from a management perspective, I will say, and Bob can disagree with me if you think so, but I think it's probably usually easier for me just because most of my, witnesses are generally managers, supervisors who are maybe more in tune with technology or whatnot, or use it more regularly. So I do think it might be easier from my perspective, but again, things happen, we deal with them, we make it work.
I can add one point here. I think one of the things that the arbitrator can do to help with this is to inquire of the parties, or first inform them that if you're using many of these platforms, such as Zoom, tablets and cell phones are not ideal, and everybody should be advised of that early on. And so if the parties know that one of the witnesses only has a tablet, only has a cell phone, then perhaps there's time to get a rental to that witness before the hearing takes place. Another common thing that happens is you start the witness starts his or her testimony, and the internet signal isn't strong enough. The arbitrator needs to be attuned to that and move very quickly, be able to move seamlessly to directing the witness to go to audio for their audio while staying on video on their computer. And that can be done very quickly, but that's why we at the Academy are trying to run these office hours trainings for arbitrators, so that the parties will have some confidence that we know what we're doing and we can help them work through these hiccups as they come up.
So in your orders, do you lay out the emergency phone numbers and the like when you lay out the protocols to be followed?
Yes, I require an appearance list to be submitted to me at least 48 hours before the hearing, and with everybody's phone number and cell phone, everyone that either party thinks that they're going to want to have at the hearing, irrespective of whether they're going to be a witness or not.
The virtual hearing order that I ripped off from the AAA on page 2 has all of this laid out very nicely. For example, going back a step, each party will be responsible for testing the video conferencing system with each of their witnesses, including third-party witnesses. Next paragraph, the technology used by everyone will be of sufficient quality to allow for clear video and audio. Next paragraph. So all of that's there. There's backup conference lines, etc. In my first one, I asked the AAA, didn't end up using it, whether they would set up a the conference call numbers that they would normally have for management calls, just to have one available, and they were willing to do it. I ended up not doing it, but you definitely need a backup. And let me just make one point on the third party. Again, at labor, you may have third parties. I would think more typically it would be the employer's witnesses and the union witnesses, but there could be third party. Third party witnesses are much more common in employment, and who's got control over the third party witness? They've been subpoenaed in there. They may or may not have counsel. So that's a real risk in the employment cases. And when there is a circumstance where there's a concern that the person doesn't have bandwidth, doesn't have a suitable device, hey, counsel, give them a laptop. Go find a way. It's your responsibility to find a way. We need to get this done. We need to get it done. If it's a witness important to you, then you better find a way for us to be able to hear him or her. and to have their testimony submitted.
Well said. I want to let the audience know that the CLE code for this is SS 9093. SS 9093. Okay. Well, and I'll repeat that later. Concerns and considerations. Well, you know, the one thing, we had a lot of discussion, and there were some interesting questions with respect to the extent to which the arbitrator can pull the trigger and contract language and the like. But what is the alternative? If an arbitrator does not feel the atmosphere is a safe atmosphere for an in-person arbitration, what options does the arbitrator have when there is resistance to the virtual arbitration and possible arguments about contractual restraint?
Well, I think under the labor management context, if the parties insist upon an in-person hearing and the arbitrator isn't comfortable about doing an in-person hearing, my opinion, and I think is consistent with the code, is that the arbitrator probably has an obligation to withdraw and allow the parties to select an arbitrator who will do an in-person hearing.
That's my view.
Okay.
In fact, I think we're getting to the stage where the arbitrators might have to make that disclosure on the upfront. If there's a medical condition or something that's going to preclude them from ever, or in the near future or distant future, appearing in person, I think that's a disclosure that needs to be made in fairness to the parties.
Okay. Now, sometimes you get in a box. Amy, you said you were in a box at one time and you actually had a virtually distant arbitration. Can you, to the extent you can, relate how that came about and describe your experience?
Sure. And so the circumstance was, as I mentioned, I have a client who, it's an essential business. They've been operating throughout the entire pandemic. So both my client and the union insisted on having an in-person hearing. Of course, you know, I had some reservations about going to the hearing. And I'm not advocating, I want to make clear that I'm not advocating for in-person hearings. I think people should do what they're comfortable with and what's the safest. But we did come to a pre-hearing agreement, much like the agreements that we have for virtual arbitrations, about all the precautions that we would take. We did not have a court reporter, which was, I normally prefer to have a court reporter, but we did not have one. This client and this union just normally do not have one. And it was good because we had one less person in the room, right? So you could be farther away. We had the table set up so that there was nobody closer than 6 feet to each other. We wore masks the whole time. And Mark, I think you're the one who touched on this point, you know, how can you judge credibility while wearing a mask? But, you know, also I had the issue, I wear reading glasses where my mask kept fogging up as I was reading my opening statement. So that was a little bit of a snafu. But we had antibacterial hand wipes, hand sanitizer on every single table. So each person had their own. We had the room deep cleaned that morning, and there was a spray and wipes to wipe down the witness chair. Everybody had their own copies of exhibits. There was no sharing of exhibits. And we did have a couple of witnesses testify by phone who did not want to appear, and we did not compel them to appear. So it was definitely different, I will say that. But again, it was actually, I think, a function of the fact that they're an essential business. This wasn't a out of the ordinary thing for them to come to work.
Okay, yeah. I think that these challenges will persist the questions, some of the questions that I've been getting are, is this going to be the way of the world? Is virtual arbitration here to stay even after the pandemic is over?
Well, Mark, let me take a crack at that, because in my paper that I wrote for the Academy workshop, this is well before the pandemic, what my research showed was that in a number of instances, this was already the new world. Many administrative agencies, both federal and state, have been running virtual hearings for a very long time. Social Security Administration, for example, has been doing virtual hearings for a long time. In international arbitrations, the virtual conference hearings have been going on. So this is not new. It has struck us now that it's something that we have to get on top of, but it was already developing.
Okay. I'm going to jump off of that because I got a question in where the feeling is that presentation of exhibits, the more discussion should be devoted to the presentation of the exhibits, that the audience would want to hear a little bit more about that. You've all talked about the use of Dropbox and exhibit sharing. I did it pretty simply in my video arbitration, and that was because I was pretty lucky in that regard. It was a disciplinary case, not a lot of witnesses, not a lot of exhibits. There were a lot of joint exhibits agreed to, and the employer and union exhibits were minimal. Additionally, the collective bargaining agreement was only 35 pages, so all of that was digitized and presented to me in a PDF. I was the court clerk. I put those exhibits up on the screen, and in screen share, each party had their witnesses have a hard copy. The parties policed, and I oversaw and admonished about making sure that the exhibits only look at the witnesses they are directed to. We panned the location and make sure that the location had no other people around. And every time a party sought to have an exhibit presented in screen share, I would put that exhibit up, and it worked well. What has been your experience, Homer, and your technique?
One of the things that's included in my scheduling order is to notify the parties that however they want to designate the exhibits, my preference is that they designate them joint employer union, and that they Bates number each exhibit so that no exhibit page repeats. So joint exhibits run from, if there are 5 and there are 35 pages, then there are 35 pages. And that assists everyone in being able to identify the documents at the hearing. We can go to the exact page that counsel is referring the witness to and be assured that everybody is on that page. The other method that I have used, and I was using even before the pandemic, was described by Al earlier. That is, have the parties both send the documents that they're going to want for that witness in a sealed envelope, because Al, they were concerned about witnesses seeing the documents beforehand, and then have the documents, have the witness open the envelope on the screen at the time that counsel is questioning. And before that, doing the Miranda warning for the witness, who's in the room, Do you have anything in front of you? I have modified it now, Al, at your suggestion. I do it after or before they take the oath. And those are the kinds of things that we do in order to ensure the integrity of the hearing. And to my knowledge, they have worked thus far.
Okay, and I know there's plenty to be said about this, but we have run out of time. So I'd like to thank my panel. You guys have been outstanding. Amy, everybody wanted to see your hedgehog because I talked about it, but I guess we're going to have to do something else about that.
Next time.
The CLE code again is SS 9093. And this has been an enjoyable presentation, and I hope you all enjoyed it as well. Everybody stay safe and take care and wear masks. Thank you.
Thank you very much.
Thank you, everybody.
Thank you.
Mhm.